we will call the next case, Florida Power and Light versus the City of South Daytona.
Reset this, and we switch that one to 10 o'clock.
If we start real quick, they won't be able to rebut. Did they go to get...
I'm not above that.
Have they gone to get your opposition?
I think Alvin might have taken seriously the bailiff's suggestion that it would be about an hour before we would just... Never mind, I'm sorry, here it comes now.
Okay, if he's not ready, we can wait. Good morning.
Good morning.
Mr. Pakelja waived argument on your behalf, so we're about finished.
He knows it as well as I do.
Good morning. Since we have appeals and cross appeals, the order in which I intend to proceed, unless you gentlemen have some other understanding, would be FP&L makes its main argument. South Daytona will reply and argue its initial position on cross appeal. FP&L gets rebuttal and a reply to the cross appeal, and then you get to get the final word in on your cross appeal issue. Okay, so if you want to reserve some time for your various rebuttal times, just let me know, and I'll try to set the clock.
Well, I do.
So you get to go first and third. He gets to go second and
But
fourth.
my third would be regarded as my rebuttal time.
The third will be your rebuttal as well as your reply to his cross appeal.
Okay.
Although I think the issues are probably so intermixed that...
Well, actually, I think they're fairly distinct, but I guess then I'd like
We're going to talk about FERC jurisdiction right now, I think.
Pardon?
I think we're going to talk about FERC jurisdiction right now.
Yes, that
Right.
would be the first one, and I think I'll take. I'd like 15, and we have 20 minutes.
Yes, sir.
Yeah, I'd like 15, and then I'd reserve 5 for my
Okay.
remaining 2 arguments.
All right. Whenever you're ready, sir.
Yes, Your Honor, thank you. Alvin Davis, representing Florida Power and Light. Our initial appeal addresses the question of whether the trial court had authority to rule on FPL's ability to seek stranded costs. I would point out that the initial petition in this case filed by the city, the only relief sought was that FPL continue to pay the franchise fee after the expiration of the franchise during the negotiations between the parties for a subsequent franchise. That was the initial petition. An amended petition was filed shortly thereafter in which they asked the court to decide what the city would have to pay to acquire the assets in the city pursuant to the language in the franchise agreement. In neither the initial petition nor in the amended petition was there any reference to stranded costs, and at no time in the case was FPL seeking stranded costs from the city as a part of the termination of the franchise agreement. It was raised in a sense when FPL simply informed the city that if you become your own utility, there may be stranded costs, but it was not as part of a demand under the franchise agreement that they pay us anything. It was simply informational. The city, in the course of discovery, presented witnesses who were going to testify about whether stranded costs would be collected or not. Because of that, FPL filed a motion with the court to exclude consideration of stranded costs because it was not within the jurisdiction of the court.
Let me ask you this. You take no issue with the trial court's determination that as a matter of contract interpretation, FPL is not entitled to any kind of stranded cost component of the asset purchase price, correct?
No, I take no issue with that whatsoever.
And then, so the only issue you would take is to the extent that the trial court is trying to say that they're trying to bind FERC or the Florida Public Service Commission and say they can't address stranded costs in the event that the city seeks to use the transmission services of FPL to wheel power from some third-party supplier, that's just not an issue that was should have been addressed by the trial court, and the order has no preclusive effect on FPL's ability to go to FERC and get stranded cost determination in that event. Is that accurate?
Yes. It's an interesting point because the court in the opinion said that we can't go to this court or any other court.
It's interesting how does the, I guess, the December 6, 2011 determination of FERC, I mean, after getting this order which attempted to, I guess, preclude a decision by FERC, the city went and got and asked for a declaratory judgment from FERC, which seems to, I mean, FERC seemed to address the issue with respect to wholesale purchase from FPL and seemed to say in that order that, and if you ever try to wheel power through FPL's transmission lines from somebody else, then we're going to determine the stranded cost at that point. I mean, it seems like FERC's already decided the issue, and whatever the trial court said didn't even appear to be raised as...
That made for an interesting tap dance in the court because when this issue came up, one of their witnesses testified on my cross-examination that FERC had exclusive jurisdiction, and I further inquired, well then, if we wish at the end of this, whatever the court rules, to go to FERC, is there anything that prevents us from doing that? And he said, oh no, you can go to FERC. And so I had to say to the court, in candor, I said, Your Honor, we don't believe the court has jurisdiction to rule on this, and I need to advise the court as a matter of courtesy that even if the court decides to rule on this, and even if the court decides we can't get stranded costs, we will still be going to the FERC. I think that the way the court in its ruling clearly invaded the province of the FERC. Because as we set out in our brief, and probably somnolescent detail, this is an energy policy that was established. And the policy has two parts. The first part is that to allow municipalities like South Daytona to become utilities, they have to have access to transmission lines which are controlled by the major utilities. South Daytona is not going to build a transmission system. So in order to give them that opportunity, because as we note, there's increasing availability of power from multiple sources, the FERC said, you have to make your transmission available to everyone at your cost, so that that's open access. It costs you this much to use your transmission, you can charge South Daytona or anyone else that much to use your transmission. The balancing point was, and the FERC recognized in the language that you can see in the cases, that the utility companies had been relying on recovering the costs that they expended in serving these small utilities. They are now losing. So the balancing point was, if a South Daytona decides to become its own utility and decides to use this open access, which it did not have before, then the exchange for that is they may be required to pay the stranded costs.
Let me ask, with respect to the FERC orders 888, prior, which I think was in 1996,
yes, Your Honor.
Prior to that order, would a city, assuming that the city had the right to purchase the system, let's say in 1994, could they have bought their wholesale power under the law that existed at that time, before 888? could they have purchased their wholesale power from anyone other than FP&L?
They could have purchased it from anyone they wished, but they wouldn't have been able to transmit it.
Okay, so, but as a practical matter, unless they ran their own transmission lines,
Right.
you were under no obligation to allow a retail turned wholesale customer or a city municipal utility to use your transmission lines to facilitate purchase from anyone else.
We were not.
So the concept, although I understand from an accounting perspective, the idea of stranded cost or sunk cost, I mean, that certainly existed in the accounting world.
Yes.
Was that in the utility world, was that something that was utilized? Did it have a place if they could not go out and buy it from anybody else or transmit it?
Really did not. We among ourselves have said, what were they thinking about in 1948 when the original franchise agreement went into effect with this language? What was the city going to do if they decided to buy the utility system? And the answer was, we've gone back and looked at various things for various reasons. I'm sure the court's aware that there's this ongoing chess match in South Daytona about whether they're going to build it and when and how they do it. But in the time of the initial franchise agreement, they could have built their own generating facility because the city of South Daytona was so small. When they voted on the original franchise agreement, it was 116 in favor and 39 against. So that was the population at the time. So if you wanted to become your own utility, you could if you built your own generating plant, but there was no availability of transmission. It's this open access transmission rule, or order 888, that made all of this possible.
Related to that, the trial court's order is sort of bizarre in that it seems to say what you find problematic, and I would too, that FPL can't go to FERC and get a determination of stranded costs in the event that the city seeks to wheel power from some other utility and use your transmission services. But then at the end of that discussion, it says that I therefore declare that FPL has no residual right to claim or assert in this court or any other court a claim for stranded costs which was available to be considered by the parties' agreement in 1978.
Yes.
Well, since these costs that we're talking about, the stranded costs associated with wheeling power through your forced wheeling of power through your transmission, weren't available for consideration prior to 1978, I'm wondering if the court really even addressed the issue at all. Maybe not. It's sort of unclear.
We've paused on that as well. There was testimony from witnesses for the city that the concept of uneconomic costs existed, and no one can disagree with that. But what we raised in the motion that we filed the court to exclude consideration, and what we've raised in our papers here, is that there was no possible way that the parties could have anticipated this and have dealt with it in 1978. I'm trying to figure out what would the contract language be. We don't know what may happen in the future, but if anything happens in the future that leaves us with stranded costs, you have to pay for it. I can't imagine the city would have agreed to that. No, these stranded costs, and it's clear in the language that we cite from the FERC decisions, that this transformed the parties' expectations. This was not something the parties could have expected. This transformed their expectations and changed them. And so what we argued before the court, and we're arguing here, is this is a policy by the federal agency charged with the responsibility for establishing this policy, and the trial court can't lop off half of it. It interferes with the supremacy clause of the Constitution, and it interferes with an area that the Federal Energy Regulatory Commission has clearly carved out exclusively for itself.
Let me try to divide your argument in two. You have a subject matter jurisdiction argument, and you have an argument that it was error to find that there was no right for FPL to claim stranded costs. On the subject matter jurisdiction, let's change this situation a little. Let's say it was a 10-year franchise agreement entered into 1998 after Order 888. And that provision said, and FPL waives any claim to stranded rights, stranded costs, should the city exercise its right to purchase the equipment. Could a trial judge have jurisdiction to say you've waived it in that
Yes.
scenario?
Yes.
Okay.
If they expressly put it in the contract, knowing of the existence of it, they waived it.
But it seems to me there's a separate argument in this scenario that the trial court was wrong to say it was foreseeable, as opposed to the trial court having the right to determine entitlement.
Well, we don't think the court had the right to determine entitlement, period. And,
But why would they have the right if it was a 1998 agreement?
well, under that scenario, we might argue the same thing, that you've waived your right, but the issue of entitlement would have to be raised with the FERC, and you could raise that argument with the FERC, but the state court shouldn't address it under any circumstances, even given the hypothetical that you just raised.
So you would say even if they had that in 1998, the trial court shouldn't address it?
The court shouldn't get into it because all of the cases make clear, and interestingly, the city in its brief states that if the court attempted to address entitlement, our argument would be correct. However, it's characterized as it's a contract issue, it's not a FERC issue. What the court said is you're not entitled to it, and that decision is reserved for the FERC. We've covered the other arguments pretty thoroughly in our brief, and we've discussed them, sort of we've woven them in what we've been talking about so far. But the contract clause of the Florida Constitution does not apply because this is an act of a federal agency. We believe that this is also an exercise of the police power by an agency regulating this area of commerce, and therefore, as an exercise of police power, they have the right to make these changes, and we've cited the cases where that has occurred. And if you want to talk about what could the parties have anticipated in 1978, you could fairly argue that in 1978, the parties knew that transmission and wholesale power were governed by the Federal Energy Regulatory Commission, and therefore they should have anticipated that that agency could make changes that would affect them, and so the city should have anticipated that this could have occurred. But the point is, it's a federal energy policy. The court's ruling effectively interferes with what that policy was intended to achieve, which is this balance, so that the utility is not stuck with these stranded costs. And the language that the court uses is that they don't want to impair the utility's ability to compete for capital in the capital markets, because if they are to bear all of these costs, then obviously their revenues change and the appeal to the capital markets changes. So this was a very thoughtful, comprehensive policy, and we cannot have state courts. I have great respect for the state court. This judge did a wonderful job, as far as I'm concerned, in dealing with the issues which he was intended to deal with, but this isn't one of them.
You're in
reserve my time. Thank you.
Well, as I understand it, I guess I have some 40 minutes or thereabouts. Well, in any event, I'd like to reserve 5 minutes just at the very end, if I could.
You got 20 minutes, so you got 15 and 5 then.
15 and 5. Yes, sir. I would concede that the wording of the trial court's order has created some confusion. The contention by FPL throughout, and when it started this action, all of a sudden the notion, and we're talking about a municipalization of a utility, and there aren't a lot of those. And when we started this whole process, up pops the topic of stranded costs. Now, as we've said in our answer brief, we don't dispute FERC's jurisdiction. We don't dispute FERC's primary jurisdiction when someone such as the City of South Daytona, hoping to take advantage of the open access policy created by FERC Order 888, wants to access a new or third-party supplier for the purpose of wheeling power in across Florida Power and Light's transmission facilities. And we understand and recognize that at that
You understand
point,
that the order could be read as attempting to preclude that? And if it is, you would agree that the order that would be an error?
yes, sir.
Okay.
I think the last paragraph is, as the courts pointed out, the court therefore declares Florida Power and Light has no residual right or claim to assert in this court or any other court a claim for stranded costs which was available to be considered by the parties' agreement in 1978. I think that's perhaps just a little bit of a clumsy way of saying, as far as the contract action that's before the court for which a declaration of rights was sought, specifically vis-a-vis the option price, which was replacement cost less depreciation, the concept of stranded or embedded costs as it was understood at that point in time was available to have been negotiated into the contract if the parties were of a mind to. They did not, ergo, it's not part of the contract analysis.
But it seems to me that the argument is really one more of a latent ambiguity in the sense that if the city had if it had the right and had exercised the option, let's say they entered into the same agreement in 1978, but instead of it being 30 years, it was 10 years. So in 1988, they exercised the option. There wouldn't have been any potential claim for stranded costs, because until 888 comes along, you can't purchase, unless you generate it yourself or build your own transmission lines, you can't purchase power from anyone else as a practical matter. Isn't that correct?
Correct.
So I'm trying to understand how they would have had a claim, they could have considered a claim for stranded cost in 1978 when, although I recognize as an accounting principle, clearly existed. I mean, this isn't just magic that they came up with. But as a practical matter, it wasn't something that would have been considered in the contract, because unless you built your own generating capacity or built your own transmission line, the issue would not have arisen. It strikes me as more of a latent ambiguity in the contract than anything else.
Well, there are any number of cost components, if the parties were of a mind to negotiate into the contract, that they could have, but they didn't. As a matter of fact, FPL's angst with this contract from day one is the fact that it's limited to replacement cost plus less depreciation, leaving any myriad of components by the wayside that they could perhaps have negotiated into the agreement, but they didn't. So the fact that, and it's not for the court to rewrite the agreement for FPL, because as the court has pointed out, those costs were recognized, they were known of, they existed at the time. So is this theoretically a cost that FPL would never have been able to recoup given the definition of the option price? Yes, sir, that's true. Now, in any event, returning to the argument, we don't dispute, as I mentioned, that when the occasion arises, and as the court's already observed, that's already taken place. These parties have already moved on to FERC. I wasn't a party to those proceedings, but I haven't heard of anybody mention this order having been a factor in that analysis. But at that point in time, an application was made to FERC, and as the courts pointed out, FERC then assumed jurisdiction, exercised its jurisdiction, utilized its rules, policies, and procedures, and came up with its determination. It wasn't impeded in any way, shape, or form by this determination. So in defense of the trial judge, all I will say is, well, yes, I understand how the wording used in the order could be preyed upon, if you will, for the sake of trying to argue that they are now somehow preempted from seeking stranded costs in any form, court or administrative, anywhere. But I believe the intent of the order and the somewhat clarification toward the end of it clearly demonstrates that what the court's talking about is stranded costs as a potential contract remedy when it comes to the determination of the option price.
Now, are you continuing the argument that they waived the right to seek stranded costs from FERC later on, or are you agreeing that they can do so?
I don't believe they've waived the right to seek stranded costs from FERC, given FERC's jurisdiction that arises when those prerequisites are met that makes them eligible for the stranded costs, that FERC can then consider those at that point in time.
So are you agreeing that the trial court should not have addressed that issue as it did in that one paragraph of its order?
I don't agree that they waived it. I don't agree that there's been a waiver by virtue of the definition of the option price in the contract.
So you're agreeing that they can go to FERC after, should your client exercise the option and purchase power from elsewhere, that they can make their claim to FERC for stranded costs?
Yes, sir, and they already have. That's already
And
occurred.
if I understand what FERC did, FERC said if South Daytona does what it says it will do, which is enter into a 10-year agreement, and apparently there's a 10-year agreement to purchase FP&L power, there's no claim. But if South Daytona were to change that position and, buy power from the XYZ company, I'm trying to understand the argument on the preclusive effect, if any, of the trial court order. Can the city of South Daytona go to FERC and say, look, the court has already determined that they are not entitled to it, they waived it under the contract, so they're not entitled to come back and seek stranded cost? Or is it the city's position that they could go to FERC if you buy power from XYZ and make their case, and then FERC says, yes, no, or whatever they say?
As far as FERC's interest in whatever contract or franchise there is between the city and FPL, the response is, yes, they have waived stranded cost because stranded cost was not incorporated into the option price. With regard to, does that then have any preclusive effect at FERC? I'm not familiar enough with FERC's rules, policies, or procedures. To the extent they have any interest in how a local court has interpreted this franchise agreement, then it may be relevant to them. Is it my contention that in and of itself precludes them from going to FERC once all those conditions preceding that you've just mentioned fall into place? No, it's not. That is not our contention, and we've as much as said so in our answer brief.
That's my reading of your answer brief is you were disputing their right to get stranded costs in the future. Because if they had waived any right to claim it under the agreement, it was just the trial court just interpreted the contract to say they waived any claim to seek stranded costs in the future. That's how I read your brief, and that's why I'm trying to
well, in our answer brief,
deal with your statements now, because it does seem to me your statements now are different than your argument in the brief.
Well, in our answer brief, we wrote, as asserted by FPL, FERC does have primary jurisdiction over the stranded costs. Primary jurisdiction means that when the court is asked to rule on an issue that is beyond the ordinary experience of judges and juries, but is within the expertise of an administrative agency, the court should defer. And then later on, in our argument, we go on to say, or we go on to recognize that they would have we conclude, for FERC to have primary jurisdiction over a claim for stranded costs in a municipalization, the newly formed utility must have utilized the open access transmission to purchase power on the competitive market from a supplier other than FPL. This is the required nexus between the FERC Order 888 and obtaining a new power supplier that is required for FERC to have jurisdiction to award stranded costs. So it's our argument, if you will, that they have jurisdiction over stranded cost when these circumstances present themselves.
Now, are you saying that when FERC exercises, say you decide to buy from the southern companies in Georgia, you want to use FPL's transmission services as they're required to let you do under 888, that you recognize FERC has jurisdiction, but you want to take this order to FERC and say, well, this has already been decided as a matter of state law. We get to use the transmission facilities without paying a stranded cost component of the rate. No. So I think y'all,
yeah,
now,
that's never been
you
our
can
contention.
see the trial court erred to the extent its order could be interpreted to preclude a claim by FPL for stranded costs in the future, should your client exercise the option and then seek to buy power elsewhere.
Yes, sir.
Okay.
All right. We'll talk about depreciation.
Yes, sir. Now, am I 10 minutes into my response to his brief, or am I into my...
You got
Cross-
20 minutes total. How you choose to use it's up to you.
As mentioned already, we have sort of a bare bones purchase price when it comes to this franchise. It's replacement cost less depreciation. Now, these
Let me
parties...
ask you this, this isn't clear to me from the briefs, and I didn't delve deep enough into the record, but does the replacement cost figures that are not disputed on appeal at least, did they include a salvage component at all? In other words, if you're going to replace a pole, you have to go take out what was there, and it may cost more money to take out what was there than the value of the scrap that's left. So does the replacement cost include a salvage component?
Well, considering the way the replacement costs were calculated, I would say as far as the city's replacement cost, the answer to that is yes. As far as FPL's replacement cost, the answer to that is no. And because the city predicated its replacement costs on the basis of a contractor giving us a bid coming in to do what needed to be done in the way of removing whatever had to be removed, reinstalling new stuff, and basically providing us a new system in and of ourselves.
The trial court rejected that as a method of...
Trial court rejected that as a method of determining replacement costs. As I understand it, FPL came back in with the historical data saying we've been buying these parts and pieces, parts of machinery, and what have you for years. We have a database that tells us what the current value is. That's the replacement cost. I don't recall there being any component in that analysis for salvage value.
Okay.
Help me understand the stipulation. All the stipulation says, as I understand it, is that the parties will use the PSC average remaining life of each component. But then both parties identify in their pretrial stip that the depreciation rate is to be considered as a triable issue. Help me understand the interrelationship. What do those two statements mean? An agreement to use the PSC's average remaining life, but recognizing that the depreciation rate itself is a triable issue.
And the only thing I can say in that regard is...
You're old. You got to come a lot closer with that if you really want us to see it, David.
Yes, sir.
Thank you.
Fortunately, I have it here, too. So.
It's our position that the depreciation rates, which are the numbers found in the far right column, because the heading of that document, I believe, says depreciation components and resulting rates.
Right.
These numbers are depreciation rates. They are the only depreciation rates that are in evidence in this proceeding. FPL introduced no evidence of depreciation rates. The stipulation that we entered into specifically said the depreciation rates set by the Florida Public Service Commission establish the remaining life of the property at issue.
Well, let me ask you, that's in paragraph 3 of your pretrial statement, but then in paragraph 4, both parties list the depreciation rate to be applied as an issue of fact.
Well, it's still a matter of calculation.
Well, it's not an issue. The depreciation rate would not be a matter of calculation if you were just going to take the remaining life rate from that chart. If that was the stipulation, then there would be no issue of fact as to what depreciation rate. I mean, you essentially use the remaining life rate from that table as the depreciation rate.
Yes, sir.
Okay. Then why would the depreciation rate be an issue of fact if that's what the stipulation was? I mean, that just doesn't make any sense to me at all.
It wasn't. The short answer to your question was it wasn't an issue of fact. This stipulation.
Both parties
go back and rewrite the rest of the pretrial compliance. That's the short answer. Having said that, this is the only depreciation rate that was introduced into evidence. Period. The only one. There is no alternative depreciation rate submitted by FPL.
Well, they use the straight line depreciation rate. They take the life of the asset category as determined in the same FPL order that table comes from, and just divide it. You know, you can use the remaining the life, the total life. If you're using straight line depreciation, that's just a mathematical formula that gives you
depreciation rate set by the Florida Public Service Commission. This is the only depreciation rate set by the Florida Public Service Commission. It was put into evidence.
Okay.
Well, if
David, Mr. McKelger, why don't you go back to the podium?
If you use the straight line depreciation method, what would the rate be? I mean, I'm looking at numbers here, 1.9, 2.6, 4.1.
Well, if you had an asset with a 40-year useful life, I guess the straight-line depreciation rate would be 2.5 years.
Okay, so isn't that in evidence? Even though there's not a chart, isn't that, as a practical matter, in evidence that they took the life expectancy and they did a straight-line method, the judge could determine a rate in that regard?
Well, there is testimony of a straight-line method. There's no evidence whatsoever of the depreciation rates that are applied to the various assets in any way, shape, or form, other than this argument that alternatively it should have been a straight-line method.
Well, but if the trial judge had evidence that a particular asset had a 20-year remaining life, and they, say straight-line depreciation, isn't it in evidence what the rate is by doing a mathematical calculation?
It is a rate in evidence, but it's not a rate set by the Florida Public Service Commission.
Right. I understand that, but your statement was that there was no contrary evidence on depreciation rates.
Well, let me clarify that. There's no other evidence of any other depreciation rates from the Public Service Commission that were put into evidence. And the reason those rates were selected, of course, is we're dealing with an electric utility, which is a creature in and unto itself. And the parties could have literally tried for weeks what depreciation would be that would come into play that would fall within the option purchase price, but instead of that agreed we would use the depreciation rate set by the Public Service Commission. And
they clearly did not use the remaining life rate. Their expert didn't do that, and their position is that that's not what the stipulation means. I guess my question, your only argument is that the methodology used by the expert for FPL and accepted by the trial court did not meet the stipulation. That's the only argument for reversal, correct?
It did not meet the stipulation, and his opinion was unsupported by the evidence that's in the record. First off, he didn't take the depreciation rate. He also didn't take the average service life. That's the other far left column that you find there.
Well, I'm looking at FPL, the rate order in 2010, for example, on, I don't see page numbers. Oh, they're at the top. Page 67, account 364, we agree with FPL that the average life of these components is 37 years, something like. So he took the average life figures from the FPL rate case as found by the Public Service Commission and used those, right?
Who did?
The expert for FPL.
No, he didn't. What he took was a number for 38 years of useful life for underground facilities, a number for 41 years for above-ground facilities.
That's the ASL, or average service life, found by the Public Service Commission in that rate order, correct?
I don't know what he's drawing upon because he tells us to go look at a website for the supporting data that he's talking about.
Well, if you follow the link to the website, it takes you to this order 10, whatever.
That's this order.
Right.
This comes from that order. This is the result. Right. This is the resultant Public Service Commission depreciation rates and the resultant Public Service Commission average service life.
No.
They're going back into information that precedes.
That is an accelerated depreciation, accelerated service life based on adding in the salvage value.
Well, actually, that's not correct either. Yeah. Because it turns out there are 11 calculations to be made here. In 3 of those calculations, it results in a service life that is less than the average service life. In the other 9, it does not. And we pointed this out to the trial court, and we particularly pointed it out at the motion for rehearing when we were confronted with that argument. The resultant useful life, like I said, in 3 of those 9, you're correct. It results in less useful life than the average service life. In the other 9, it does not. So the assumption that the negative salvage value or net salvage value that's incorporated into this analysis somehow constitutes or ramps up an accelerated depreciation across the board for all these asset bundles is incorrect.
Okay. Mr. Bickelger, you've used your entire 20 minutes. I'm going to give you an extra 4 minutes, and I will give FP&L the same extra 4 minutes. So you want to hold your 4 minutes for your rebuttal?
So the 4 minutes I have left is all the 4 minutes I have.
You go. you got it, 4 extra minutes.
All right, well, I'll save it for my rebuttal then.
Okay. Would you mind moving that back
Yes,
for
sir.
us? Thank you. Hold on here just a second. I'm having grave difficulties today with my clock operation. I think you had about 4 minutes left, and we're going to add 4 minutes to that.
Thank you, Your Honor.
So we'll give you... While we're on the topic of depreciation, help me understand, if I understand the trial judge's order, he adopted the City of South Daytona's depreciation methodology with respect to categories 364 and 365, and FP&L's depreciation methodology with respect to the remainder. I'm not sure what the stipulation means, but wouldn't the stipulation require the judge to use the same methodology for all the categories, whichever one he decides is more appropriate? Wouldn't the stipulation lead one to conclude that the same method ought to be used across the board? Different numbers, but the same method.
Yes, Your Honor. I've been at this a long time. I know all of you have as well. I think he was giving the city a little something because we asked for $17 million. He gave us $16 million, and the difference was by using their depreciation for those 2 items. I have no other explanation for it.
And you didn't challenge that on appeal, however?
We did not.
Okay.
No. Our generosity matched the court's, I felt. So.
Let me ask you the same question. Did the cost of replacement numbers that the court accepted from FPL's evidence include a salvage value?
No, they did not. The replacement cost was calculated by our people going out and say, how much would it cost today to put this same pole in, to put these same wires in? And they came up with those costs new, and then they applied a depreciation rate to it.
And am I correct that Mr. I think it's Bellavere, your expert, used the average service life numbers from PSC Order 10-0153?
Yes, he did.
Okay.
And
then he used those on a straight line method to get the depreciation rate?
He did.
Okay.
The pretrial stipulation...
If you have a pole that costs $10,000 and, to buy new, so is that the number, to follow up to Judge Lawson's question, that's the number your expert used, even if in reality the person would have to take the other pole down and put your new one in, and maybe
Yes.
it costs $1,000 to replace it?
Yes, that's the number, because that was the formula. The formula in the contract was replacement cost new, less depreciation.
Less depreciation to date. I mean, I think there would be an argument that the contract requires the use of the depreciation that FPL had actually taken on that asset, which would be in some instances an accelerated depreciation. But I guess that argument's not made here.
No.
Okay. I mean, to me it makes more sense to use, I mean, the ratepayers, including the city customers, have already had their rates set to pay for these assets. The assets get transferred. To the extent that they have a net salvage value, then that liability that used to be FPL's on which the rates are based is now transferred. It would seem like it'd be fairer to transfer, if you're transferring the liability, that the rates ought to account for that.
Well, that argument was made. It's a public service related argument that they tried to bring into the court. I mean, the response to it is you can depreciate something, and the court made this point. I have a truck, and it gets depreciated over 10 years, and I continue to drive it for the next 6 or 7 years, so I'm getting value. The formula was a way of striking a balance in the point you raise and the fact that you've got value after 30 years, because Public Service Commission does these calculations for its own rate-setting purposes, and that was the distinction the court made. But I want to clear up what the stipulation provided. The stipulation that we agreed to, and this was raised that Mr. Vukolja made the same argument in the trial court, that we did not agree to use the Public Service Commission depreciation rate. We agreed to use the Public Service Commission rates for purposes of establishing the life of the item.
I mean, that sort of is inartful to me if you look at the order. I mean, if that's what you meant, you should, the stipulation should have said we're going to use the average service life as determined by the Public Service Commission. That makes sense.
That language is...
Because there's no depreciation rate you can look at in that order to get back to the average service life.
Right, but we weren't looking at the rate to get to the service life.
That's what the stipulation seems to say. We're going to use a depreciation rate to get to the average service life when the service lives are in the order, and you can't backtrack from the ultimate rates that include salvage value to get to that.
Well, this is one page of a 130-page order that Mr. Bellemare considered. The purpose of it was to reach agreement on how long these things are supposed to last. Then you go out and you actually see how long they've been there, and that's how he calculated his straight-line depreciation. But the stipulation is very clear. We said that the depreciation rate is an issue of fact that has to be decided by the court. They said in the stipulation that the depreciation rate is the rate that has to be decided by the court.
Let me ask you this. At the time the pretrial stipulation was done, I assume that was shortly before trial, week, month, whatever,
Yes.
shortly before trial. Were depositions taken of the two experts?
Yes.
And they were taken prior to the pretrial stipulation?
Yes.
And there would be apparent to attorneys that they were using different depreciation rates and different methodologies
Yes,
and
the
coming up with different values?
deposition of Mr. Bellemare is completely consistent with his trial testimony that we were not using the depreciation rate of the Public Service Commission because it includes salvage component. I mean, that was a big focus of the trial court. There was only one expert on business valuation that testified, and that was Mr. Bellemare. And he testified unequivocally that salvage value is not a factor in determining the value of an asset for purposes of valuation. So he did not include it. The court accepted that because the court recognized that the use of salvage value in the calculation accelerates the depreciation of the asset and doesn't represent the actual value of the asset. So the court was presented with two distinct rates of depreciation. The court adopted FPLs because FPL had produced the only expert, because the court found that that expert was reliable. He found that the testimony of the expert of the city, Mr. Poos, was unreliable. Mr. Poos and Mr. Booth, both the city's expert, both testified that the depreciation rate that they employed to come up with replacement value less depreciation included salvage value. The court made the determination that salvage value is not an appropriate element in valuation, and therefore, and he had ample support in the record for his conclusion.
Well, let me ask you this. While your expert was testifying, were there any objections that his testimony was going beyond what the parties stipulated to or was contrary to stipulation? Was that first raised during closing arguments?
It was not raised while he was on the stand. There was no objection to his testimony.
Was it raised before he testified?
No.
So when was the first time it was raised? On appeal?
Yes.
Wasn't raised at closing argument either?
No.
All right, sir. You've exhausted your time. Thank you so much.
Thank you.
If the court is inclined to think that calculations taken from a website would suffice, the fact of the matter is Mr. Bellemare did not use an individual average service value for every asset bundle. He picked two, 38 for underground and 41 for above ground. Two numbers. You have 11 calculations, each of which would render its own useful life. And you won't find 38 either as a function of the depreciation rate, and you won't find 38 under the column of average remaining life. You won't find that number anywhere.
You say a website, but that chart that you're looking at is page 79 of the order that's at that web link. I mean, the average service life numbers come from the same Florida Public Service Commission order that chart does.
This chart was put in evidence. No website was put in evidence.
Did you object to the testimony as it was being proffer or given at trial that this testimony is inconsistent with the stipulation?
We asserted that ours was the only calculation that was consistent. That was the argument at trial. They only have two numbers. They use two numbers to calculate all underground assets, 38. They use another number, 41, as the basis for all above-ground assets. In addition to that, they add 3.26 years remaining life to every underground asset so that you'll never 100% depreciate anything. They add 4.455 remaining life to every above-ground asset, so once again, you will never depreciate anything down to zero. None of these factors are found in the depreciation rates that were agreed and were introduced into evidence. This is the chart that the judge refers to in his final judgment when he refers to the Florida Public Service Commission schedule.
I think that what's stated as a stipulation is inartful at best. I mean, I can't really tell what you're supposed to agree to. I think you might have an argument, except that you right below that said that the depreciation rate is an issue of fact to be tried. Both parties stipulated or said or told the court in its pretrial statement that the depreciation rate was a factual issue. Given that, I don't know how you can now say that no, it's not a factual issue. We agreed to those depreciation rates. I
don't have to say it's not a factual issue. There's no depreciation rate from FPL to be found in the record, period. Even the website that they're referring to does not include a depreciation rate that enables you to arrive at the calculation of the 38 years and the 41 years that they utilized. There's so at its absolute bare minimum, we clearly stipulated that depreciation rates from the Public Service Commission were going to determine depreciation. These are the only depreciation rates in evidence. There are no FPL depreciation rates in evidence anywhere.
Just so I'm clear on the stipulation, I thought that stipulation was the average, that you would use the average useful life.
The stipulation says
a depreciation rate set by the Florida Public Service Commission established the remaining life of the property it is.
Right. And that is not a straight line depreciation method, because once you incorporate these numbers, the top number, 4.1, you divide 4.1 into 100, that leaves 24.39. That is your average life then for that asset. That is not a straight line depreciation. This stipulation in and of itself contravenes the notion that there would ever be a straight line depreciation result or calculation here, because we were taking into consideration the Public Service Commission's.
The problem is it contravenes the notion that there would ever be an argument or testimony at trial as to anything about depreciation rate. I mean, if it says what you say that it says, then the testimony of both witnesses would have been irrelevant as to what depreciation rate you should use and how you should do it. I mean,
when it came down to the determination, the entry of the final judgment, the judge incorporated this stipulation in. At the rehearing, everything was laid out for the judge. This was an opportunity for him with crystal clarity to see what exactly had been done. And the judge's response, after having been confronted with these calculations and showing to a mathematical certainty that they didn't comply in any way, shape, or form with the stipulation, was that, well, I had to pick an expert, so I picked FPL's expert. That was the rationalization.
Mr. Kelger, you've exhausted your time.
Yes, sir.
Thank you.
Gentlemen, I thank you very much. I'm sorry,
Thank
Your
you
Honors.
both.
I thank you very much. Thank you.
Thank you all very much. Well argued.